Welcome to Conveyancing Matters. Stu and I are delighted to welcome Rob Hailstone to this chat. Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property. So, welcome to Conveyancing Matters. Lovely Rob Hailstone. Delighted to welcome you at the end of 2023. How on earth are you?
I'm very well, thank you, Lorraine. Looking forward to Christmas. I've got my Christmas jumper on, especially for this recording.
Yes.
And we're particularly excited because between now and the 2nd of January, we should have a new grandson arrive.
Oh, well, that's just the very best news. We probably ought to just stop the chat now, Rob, because nothing will beat that. What a fantastic piece of news. Well, congratulations to all of the family when your little chap arrives. What a fantastic present that will be. Will you be able to wrap him in that gorgeous jumper, won't you, Rob?
I expect so, yes, and he can stroke my lovely beard.
Yes, exactly. And Stu, how are you?
I'm very good, thanks, Lorraine. How are you? You all right?
Yeah, I'm good, thanks, lovely. I'm good, thanks. Well, we can't get Conveyancing's guru, Lifetime Achievement Award winner and all-round good egg, Rob Hailstone, on without asking Rob, how do you think 2023 has been for conveyancers? You're one of the best placed people in the industry to comment with Bold Legal. So what's your view? What's your overarching view? I think it was all a bit doom and gloom at the beginning of the year. So how do you think the year's panned out?
I think it's been a 50-50 year, really. The property market has been a lot better than we expected. Transactions don't seem to have fallen off a cliff, a bit quieter now, but they've ticked along quite nicely, and the conveyancers have been busy enough. I think the problem with 2023 has been, well, initially, the Building Safety Act. I know we didn't want to mention that too much, but it came to me in a while ago. It's still there. It's still causing problems. There's been other issues as well this year that have kicked off later in the year. The cybersecurity incident. We've had conveyancers have had 2 or 3 consultations to look at, of course. The change of code for exchange, the leasehold issue, etc. And the problem is they don't have time to look at all these things, especially when they're thrown at them at the same time.
Yeah. So, well, just on that one, Rob, I mean, we'll pick a couple of those apart, but, well, perhaps I'll start with you, Stu. I mean, has any conveyancer, I'll ask this to both of you, Stu first, has any conveyancer at any point in the last 5 years said, goodness me, the formulae for exchange are terrible and we need a new way to exchange? Has that been on anybody's conveyancing radar, Stu?
No, honestly, I don't think I've ever heard anybody criticise the formula for exchange ever. Maybe we discuss Formula C and its relevance, but other than that, I really don't see the need really to amend it. And of course, potentially, I think the new variant might be more confusing.
I think so.
Might cause more problems, but in the grand scheme of everything that goes on, yeah, potentially that wasn't one that we could have done with. But
we saw coming.
Yeah, maybe, yeah.
And Rob, what's your view on that?
I think I've seen a few people say, I'm not quite sure what they mean by this, but can we exchange digitally? Now, whether this new code will do that, I'm not sure. Maybe they mean exchange by email. But no, things have been working pretty well up to now. I think it's going to confuse the matter. The consultation is now over anyway.
Yeah.
It didn't seem to be a proper consultation either.
No.
No. They invited my members to send their responses to me and me to summarise them and send them to the Law Society. Well, I thought, well, okay, not really. No, thanks. I'm too busy for that. I did pass on the contact details for my members. I doubt whether many have been able to respond.
Because they were too damn busy. No, I mean, it's a 12-page PDF. And as you say, Stu, Formula C, solicitors have, conveyancers have tended not to use that because they don't understand it. But but what worries me about it is they have said the way you exchange is changing, and they've called it the 2024 code. So you can't help thinking that very short consultation, Rob, with that really short turnaround was rather a fait accompli. You feel they'd already perhaps decided, dare I say. And
there it is. If nobody's read it, I don't know if you can see that, but yeah.
Not quite, but yeah, I'm just very surprised by all of it. And of course, what they also say, and I don't know whether, again, your view, Stu, SRA regulated firms that have got the conveyancing quality scheme will have to, as part of the protocol, use the new exchange code. But of course, you know, half the conveyancing firms in the country are CRC regulated and won't have to. I mean, that's surely going to cause more confusion.
The problem with it is that they've used the word confusion that surrounds, you know, exchanging contracts. Well, I don't think there is any confusion. And what this has introduced is the potential for there to be plenty of it. Not only insofar as it's not mandatory within everybody's regulation, but also what they're purporting to agree pre-exchanging and stuff like that. You know, when you exchange contracts, you know, it's that point that everything becomes definite. So pre-agreeing things, to me, is a total waste of time because, of course, they could change. So I don't really get the ethos behind it either.
Well, I have no confidence actually at all in being able to pre-agree anything, because I imagine everybody watching this will have the situation where, for example, when you're acting for a seller, you have spent literally the entire transaction up to exchange trying to find out something simple like how much deposit is on offer, and you only find out how much deposit is on offer at the moment you're about to have that phone conversation and exchange. And if you find out at that point it's less than 10%, you've then got to get off the phone, not exchange, and go and take instructions from your seller. So this idea that we're going to be able to pre-agree stuff, I think it's just unrealistic. It's completely unrealistic. I just don't see it happening, I have to say, but there we go. So you mentioned the B word, Rob. I mean, the Building Safety Act, as you say, real furore at the beginning of the year. What's your, you know, you mentioned off air where firms appear to have settled. So as you said, as we said, without going into too much detail, because it's a bit of a grim subject, but where have you found the market in terms of the Building Safety Act?
I think it's pretty straightforward at the moment. About 50% of firms are taking on work where Building Safety Act does affect the transaction, and 50% of firms aren't taking on work. If you look at our online forum where you get questions and answers posted all day, every day about various legal matters, I think the Building Safety Act is still the most popular question, or based on one of the most popular questions.
Yeah.
But it has tailed off quite a lot from 2 or 3 months ago. So we probably get 1 or 2 a week now, whereas before we're getting 1 or 2 a day. Oh,
that's interesting. And Rob, just while I'm on with it, just you know, for the 2 people watching this that have been living in a cave, just remind us of Bold Legal's email address and tell us a little bit about the forum while we're talking about it.
Well, my email address is rh@boldgroup.co.uk. Obviously, I send out a weekly bulletin, as most people know, but we've also got a really fantastic online forum where we've now got 1,740 something conveyancers registered, and they will post questions, they will ask questions throughout the day. They even do it on a weekend. I'll be sat watching Strictly, I'll look at my online forum, I say to them, for God's sake, they're still posting questions. But they're also still replying to them. So other firms will come back and say, I had this problem last week, this is how I dealt with it. I wish I'd done it years ago. I would say it's now the jewel in our crown. It's fantastic. I love it.
Oh, that's really good. That's really good, Rob. So, well, Stu, we started off the year with a chat with the Land Registry, Land Registry's Mike Harlow, didn't we? Which was a good chat.
Yeah, I think the chat went really well. And in fact, it's one of our sort of best viewed videos and probably popular guests. Obviously, the trigger point with the Land Registry delays at the moment is very focal. And I know, Rob, you've had the same sort of conversation with Mike recently. So, you know, what did you make of it all?
Yeah, I recorded a podcast with him a week ago, actually. Just very quickly before we go on to that, I just want to say to your listeners, in case they don't know, the leasehold consultation has been extended. Last couple of days until I think the middle of Jan now. So if you haven't replied to that, please do. But anyway, sorry, just going back to Mike. Yeah, we had a long chat last week, about 57 minutes worth, I think, in total. The feedback from the podcast has been good, which is nice. I've got 3 relevant questions, which, if you don't mind, I'll read the answers because I want to quote Mike accurately. And the first one is, you know, the elephant in the room. Well, it's not, you can see it, it's right in the middle of the room. What's being done to tackle the backlog? Have you got more staff? And when can we see an end to all this? And Mike said, and I listened to the podcast again this morning, whenever there's been a property boom, there's been a backlog. There's only one land registry. When there's a spike in demand, we don't have people waiting in the wings to take up the extra work. Currently, we're reducing the oldest case to around 18 months at the moment. We're targeting to have no cases older than 12 months by the spring of 2024. We have 800 people in training, plus those who will be doing casework who are training those people. Possibly the biggest single investment HMLR has ever made. I'm not sure about that, but whatever. By mid-January, all will have come out of training. They will take a little while to come out of training to building up their expertise, obviously. One wonders about the requisitions that might be raised. By the end of Feb next year, we should see the age of the oldest cases, which are coming down even faster. We are on the road to no backlogs and everything being done in a reasonable time. This must be the last backlog. This must never happen again. Land registries around the world suffer in the same way in a housing boom. So that was the answer he gave to me a week ago today.
That's interesting, because actually the first part of that answer, Rob, was I think, Stu, if I'm right in saying, pretty much exactly what he said to us just under 12 months ago. We interviewed Mike in January. And whilst he didn't have the stats that you've just quoted, and perhaps unsurprisingly, but that point about, when there's a boom, the land registry is, the same size, which actually I know you picked up on, particularly, Stu, at the time, didn't you?
Yeah, because it does put it into quite, start focus. However, a whole year has passed, and I'm not sure Mike is giving enough credit to the size of this issue and how this affects conveyancers, because within our practice, certainly, I would say now it's a daily occurrence that clients are ringing in, chasing land registry, and it's very difficult to articulate to a client that actually there are, a year delays. I mean, we're still quoting 18 months. I've not heard what the latest is on a transfer of part, but it was 3 years earlier in the year. I mean, that just seems, how can you quote 3 years? I just don't quite comprehend.
Well, it does come down, Stu, and actually, if
and don't forget, Mike was very quick to criticise conveyancers at the onset of this year as well.
Well, that's obviously what actually prompted us to interview him in the first place, if you remember. It
was, and I would like to hear from Mike, if we ever had the chance to interview him again, whether, expediting applications has actually made much of a difference, and whether he thinks that's a good idea, because I'm finding in practice now that it's becoming even more of a problem, that I have clients that maybe they've bought on a development, or even, from speaking to friends and family, that they bought a property 6 months ago that's been registered. I bought my property a year ago and it's still not been registered. And it now seems to be a daily occurrence where we're having to provide evidence or proof that we've made an application.
But who did you use for the conveyancing, Stuart? That was your problem.
What was that, sorry?
Who did you use for your conveyancing? That's probably the problem. But
the problem is, it's really difficult to explain to a client how this could actually be, isn't it? Because the institution that the land registry is, I think clients are quite right to be worried, and it doesn't matter how we explain it to them. It doesn't logically make any sense. And trying to explain to a client that a year, 18 months, these figures are so high that,
and they say the conveyancing process takes a long time, up to 6 months. But you put it in perspective, 3 years, up to 3 years to register an already completed transaction is just not right.
Well,
and although I appreciate what Mike's saying, and I do appreciate that it's not as easy as we all make it out to be, but we're quite quick to talk about the other things that the land registry is doing, and the resource that would have taken, where, again, I go back to the original point, has enough credit been given to the actual the issue of the delay? Because it's all great bringing in everything else under the sun, but this is
the digital property steering group and the local land charges land grab, that's all very well, but, and I know Mike was quite bullish when we talked to him about that in January, Stu, but at the end of the day, those projects are taking resources. I don't care what you say. The land registry as an organisation is not diverting, I still think, as much of its resource to these delays. I've just had a look, actually, Stu. First registrations, so literally just Googled it, as you've said. First registrations, half of applications are done in about 14 months. We complete almost all in about 16 months. Transfers of part and new leases, half 13 months, almost all 20 months, where no preparatory work has been done, half completed in about 17 months, almost all in about 21 months. So your transfer part could still be just shy of 2 years, Stu.
Yeah, I just think that's ludicrous.
I think to a degree now, Mike's reputation is on the line here, and I did say I'd like to have another chat with him probably in April or May next year, and I'm sure you will as well.
I agree. I mean, Mike, I think, is a very, he's an excellent ambassador. I think he's a brilliant speaker. And to be completely fair to Mike, what he has consistently done is turn up to conferences, road shows, he's been prepared to stand in front of a room of 200 conveyancers and fly the flag and take the difficult questions. And for that, I absolutely admire him. I genuinely do. But as the flag bearer, the flag's going to come. And I do think that this is getting, and of course, the other point that people seem to forget, and it's the point that Stu and I make consistently, Rob, about, okay, where is conveyancers' time going? The conveyancing process, a lot of it isn't broken. Stu and I are very firm on that. It's cobblers. The actual process is pretty fine. Ergo, we don't need to change exchange. The difficulty is what people don't understand is where conveyancer resource is going. A huge amount of a conveyancer's job is now on the AML due diligence stuff that you and I didn't have to think about 30, 40 years ago, Rob. But of course, the point Stu's just made, while his staff are taking calls from clients and chasing about the land registry and chasing the land registry, all of that time isn't going into existing conveyancing transactions.
No, can I just very quickly read out 2 other questions I asked him? They're very short answers as well. I asked him, do you get too many applications that need requisitions to be raised that shouldn't need to be raised, which adds to the backlog situation? I thought that was only a fair question to ask, and I think that's what he hinted at the beginning of this year.
Yeah.
He said, yes, sometimes you're asking for things that if you paid a bit more diligence and attention to, we wouldn't have to write to you and you would not need to write back. That's a waste of time on both sides. And we want to work with the sector to help iron this out. We want to make sure people see the value of getting applications right the first time. That is a fair comment. I don't know the numbers on that, though.
No, well, I'm certainly thinking, Stu, the digital application process must be helping, undoubtedly.
Yeah. I mean, it helps internally. The only thing, you alluded to this earlier, Rob, as well, with the requisitions. We're not taking into account the volume of requisitions that might be coming back here. And again, my worry, and I know this is completely a blasé, a bit of off the cuff kind of comment, but the newer trained staff, we basically see a complete randomized approach to these requisitions. You can put the 2 applications in, one will get a requisition, one won't. You can put 2 applications in at the same time, one will come back 6 months before the other.
But isn't that a bit like individual conveyancers asking individual inquiries anyway?
Yeah, exactly the same.
Nature of the way.
Yeah, true. But it doesn't help you. There's a big problem. 6 months variance on a similar property on a similar estate, to me, doesn't seem right. And there must be some kind of criteria that the land registry apply to whether a requisition is raised or not. And when you just see the volume that comes back, you think, well, I'm not quite sure really whether they have that, on point, so to speak.
I mean, I haven't been at the coalface now for nearly 15 years. But when I was doing conveyancing, if a requisition came back to me, I always used to feel I hadn't done my job properly somewhere, either with the conveyancing process or the application process. So I felt pretty bad about myself. I'm not sure if it's the same now. I presume it is.
I would say the industry in general, probably not, insofar as I think most firms will have a post-completion department. So that maybe takes emphasis away from the conveyancer. And we've had conversations in-house here, whereby now I think the actual registration process or the post-completion process is as probably as complicated as it's ever been. You've now got ID restrictions that are on titles. Most management companies have restrictions on titles. I think as the industry's moved forward, the use of putting a restriction on the titles become a lot more common than it ever has been. And therefore, actually, the process to register something's become a lot more complicated and a lot more protracted.
What I've seen, though, from some of the bigger firms I've worked with is that, my view firmly is from a technical and risk management point of view is that the matter shouldn't exchange until the fee earner is sure and has got what they can do in relation to being, for example, able to deal with a requisition. Whereas I think what a lot of fee earners will do is sort of see any restriction as a sort of just a thing for the post-completion team to deal with, rather than actually something that needs to be addressed and the post-completion team instructed on. by the fee earner. And I think that's really quite a significant point.
Well, again, back in the day, you used to do your own conveyancing and sometimes,
Yeah.
often, do your own registration. So you had to make sure it was correct, although you ended up with the problem not passing the buck to your
I know it should be the fee owner's problem, actually, to make sure a restriction can be complied with. And they should simply be instructing the post-completion team what to do. It's not the post-completion team's job after completion to deal with a management company restriction, because you might not be able to comply with it. But I guess that's a different conversation.
It is a different conversation for another day, but still the post-completion department or their role has been expanded.
Oh, I agree. I couldn't agree
they've
more.
still got more restrictions to deal with.
Mm.
They've still got the you've now got obviously renewal of your OS1 and OS2 searches because the land registry have got delays, or because you might be waiting on things to come in. You've still got more requisitions coming back than I would have said previously, because probably titles become more diverse. So there's just more to their role as a generalization, keeping the banks happy. I mean, Rob and yourself, Lorraine, will remember the old days. We never got chased by a bank.
No.
Well, actually, Stu, that leads on very nicely to my final question that I put to Mike, if I may, and that was, can HMLR stop lenders chasing conveyancers? It's a very short reply. It's a glimmer of good news, I hope, but he said a number of lenders will receive information on where their application is. They're saying as a result, they will chase only in exceptional cases. We should hear more about this early next year.
That'll be interesting. That would be something that would at least help the profession, wouldn't it?
Yeah.
So where do we find your podcast with Mike, Rob?
Oh, that's a very good question. You don't know where my podcast is. It's out in podcast land, isn't it?
It's out in podcast world. It'll be on Spotify. There'll be a link to it from your website, Rob. We'll find it. Don't worry.
It's on Podbean, whatever that is. Yeah.
Yeah, it's on Pod something. Well, Rob, we could spend a week talking about the next topic, but shall we just take a sort of a glance over, I think, a big thing on the horizon for conveyancers and already for estate agents, the material information, the requirements imposed fundamentally on estate agents to give more information about properties up front, up marketing, but I think going to be creating more of a storm and more issues, particularly around maybe tanks on conveyancers' lawn in relation to Part C. So do you want to just give us a sort of brief overview for those that don't know much about it, Rob, as to what it is, and then we'll perhaps unpick perhaps the impact on conveyancers in particular?
Yeah, I'll try to. I mean, this is obviously close to my heart because a lot of people say that the material information changes are leading into HIPS Volume 2, which I don't think they are. And of course, I was a HIP provider. I believed in HIPs. I tried to produce an exchange-ready HIP, and when we did, it speeded the transaction up. But material information is not, in my mind, upfront information. Material information is for the consumer to make a better decision about the property they want to buy, whether they actually want to buy it. I believe upfront information is more about speeding up the conveyancing process, and that isn't happening at the moment. That might come in after material information. So material information really is, as I say, about the consumer, the potential purchaser of a property, having more information to hand before they make an offer on the property. Are they happy with the broadband coverage? Are they happy with the phone signal? Do they know whether it's leasehold or freehold, et cetera, et cetera? So in theory, that's a great idea, I think. It's also, and there's a great podcast on Today's Conveyancer Today, which is 11th December, and I did listen to that this morning. And this is building on the consumer protection regulations, I believe it came in 2008, and agents haven't really known how to comply with those regulations. The material information guidance is to enable them to interpret how to comply with regulations that came in 15 years ago.
I think probably, Rob, actually, though, because the material information has been introduced incrementally, parts A, B, and C. And I think parts A and B that agents have to comply with, which are the points you've alluded to, which I don't actually think, I've never thought that conveyancers should be whittling around getting involved with blooming, broadband speeds and all the rest of it. I think everybody would be on board with that and say, yeah, they are the things that are of interest to buyers, whether it's utilities, number of rooms, parking, etc. And of course, Part A is just the basics, price and tenure. But I think it's perhaps part C of the material information where the difficulty comes, because essentially, you know, my understanding in this, and I'm kind of looking at it in front of me, but part C is requiring more information to be put up front by the agent around issues such as, well, it's information that may or may not need to be established depending on whether the property is affected by the issue. Building safety, restrictions like conservation areas, listed building rights and easement, flood risk, planning permission, coalfield or mining areas. That list is, which is on the National Standards website, Rob. That's stuff the conveyancer revises on, and that's, I think, where I'm struggling in terms of my understanding of material information, because how does part C sit with what the conveyancer does?
Yeah, you're right. And I'm looking at the same list as you at the moment. And they do say they want a conveyancer to get involved wherever relevant, and a surveyor, come to that. But they're not saying that the estate agent has to interpret any of this. They're just saying the estate agent has to display any relevant information about easements, covenants and restrictions, etc. So if there are no easements, covenants or restrictions, they don't have to display it. But if there are, what now suggesting or recommending is that the agent says to the seller, look, we've got these complicated restrictions, easements, whatever. We suggest you go and instruct a conveyancer to help explain what they are and how they may or may not affect your onward transaction.
But how is an agent how's an agent going to display that? What are they just going to do? Make the official copies available?
I guess, I mean, that remains to be seen how they're going to do it, yes, and we'll get to policing and enforcement in a minute, I guess. But yeah, they've got to put. I think at the moment, training standards don't really mind how they display it, as long as they display it, even if it's on an A4 document. But they should start displaying it. Of course, this came in, I think, on the 30th of November, and it actually came in that day. It's now live guidance. There's no warm-up period, really. Well, B and C came in on the 30th.
But I think what this is doing, particularly regarding this Part C information, and Stu, I'd be interested clearly in your view, as I say, restrictions, listed building, TPOs, public rights of way, shared drives, flood risk, planning permissions, and planning permissions, Stu, it says for the property itself and its immediate locality. Well, we all know that the local search only searches against the address and not the immediate locality. So, but this to me seems information without context. It's the conveyancer that puts this information into context, surely, in the context of a purchase.
Well, that is the problem, isn't it? It's how the information is utilised. And Rob, I'm not so sure that and I might be speaking completely out of turn, but I'm not so sure the average estate agent is actually going to push that information or push a client to then go and speak to their lawyer when they're potentially looking at a property. I think the more likely scenario is that will be glossed over. I'm not so sure it's actually going to be fit for purpose when you start getting into rights of way. And also it's interpreting the right of way, isn't it? If you're talking about a right of way, I don't know, it could be a rear passage, it could be on foot, not by vehicle and on foot, and therefore it's not just identifying that there's a right of way. It's you're trying to tell the client something, and I'm not so sure that an estate agent is going to be best positioned to really do that. Whether they're going to then, ask for a conveyancer to get involved when potentially that might open up a can of worms that could prejudice the purchase and the sale. Can't see that happening myself.
It's like the example of shared drives. So, anybody can look at a title plan, possibly even a transfer, and say, yes, there's a shared drive. But who's going to interpret whether there's a shared drive, whether there's a right of way over it, and crucially, what's the legal mechanism, to capture the positive obligation to make, to pay for the upkeep is quite a different thing. And I think this is the bit that sort of bothers me, Rob, really around, Stu has said before, people don't want to instruct their conveyancer up front, and the seller's not going to want to get their conveyancer to tell them stuff that they should already know. The seller isn't going to really care about this stuff.
No, I think from the estate agent's point of view, and Stu said they might gloss over it, I think they're worried about any potential liability coming back to them.
I bet they are.
And so they should be, yeah.
If they don't say to the seller, right, go and instruct a conveyancer. And I've posted a comment on today's Conveyancer Day saying to the agent, look, if you do that, you've got to record what you say, who you say it to, and when you said it. Because if the seller doesn't then decide to go and instruct a conveyancer, that is probably their fault.
But
Mm.
also, Rob, what I'm interested in, and again, there's a piece in today's Conveyancer, dated today, 11th of December, which is brilliant. And I think they've done a podcast actually with James Monroe, the head honcho at the National Trading Standards. But again, and there's this suggestion that an opportunity for a change in the way conveyancers offer their services. Well, what James has said, and actually, Stu, we perhaps ought to get him on. But this idea that the seller or buyer, for that matter, the buyer particularly, will instruct their conveyancer up front. But James Monroe acknowledges any early involvement by the conveyancer needs to take account of capacity of the profession and current charging methods, suggests that a limited upfront package might include a caveat that should the transaction move forward, the firm would act on the matter. Well, that slightly suggests to me that conveyancers are going to be expected to essentially give free advice.
That's the whole thing. That's why, practically speaking, it's never going to happen, and that's why an estate agent will gloss over, because you're not going to come to a law firm, instruct a lawyer, potentially pay money on account to look into matters when
But I think, Stu, there are some firms already, and I know one or two names, who are offering free advice to estate agents to assist them with this. They're already out there doing it. Now, I've been banging on about Phase A material information for the best part of a year, and I've been saying to my members, go and talk to your estate agents now. I would have been talking to my estate agents 6 months ago about Part A and potentially Parts B and C, even though we weren't sure what was going to be in them. And I'd be sitting down with them now in a room saying, right, this is what you've got to do. This is how we can help you. How can we structure this so it's a commercially fair arrangement for both parties?
We've done that, Rob, and thus far, not one's come back to us yet. And I go back to when we looked at HIPs and when HIPs were abolished, we set up whatever you want to call it, a brand or a scheme, whereby basically continuing on the HIPs theme, as much information up front, as much information completed at the onset. And although when we used to go and see estate agents, use that as a selling point to recruit work, we'd get the work, but still the agents were very, very, very reluctant to do anything in addition and supply any upfront information or get the clients to complete any forms.
Well,
so
when I set up the Bold Legal Group, Bold was supposed to stand for Bundle of Legal Documents, Stu, and that was 13 years ago. Because I still believed in information up front, and to a degree I do. I think Lorraine touched on something earlier when she said, not many conveyancers know about material information. I'd go even further and say not many estate agents know about it as well.
Oh, yeah.
Yeah.
The ones who read Property Industry Eye or Estate Agent Today, I think the other 10,000 probably don't know.
I think the interesting point, though, is just picking up on something you just said, Rob, and I think it's the involvement of the conveyancer. I think there's two distinct sort of aspects to this. I think those conveyancers that are saying to their agent contacts, as you've suggested, there are them out there, and frankly, good on them. Let's work with you. Let us help you to interpret material information so you're getting the right stuff out there. I think that's one thing, but I think that whether that then bleeds into the conveyancer effectively giving some, free or cut price advice to a prospective buyer on a purchase before, for example, the buyer might, there might even be a retainer with a buyer client. And again, it's my concern about this is not more information going out up front, not at all. I think that's got to be a good thing, but it's finding where the tipping point is, because again, for me, this is information without context. And Rob, as well as I do, how can we advise a client on these issues without the know your client and without the context? Because, for example, I jotted a couple of examples down for myself. A client who doesn't want to run a business from a property isn't going to be bothered about a residents only covenant. And a client who doesn't want to apply for planning permission isn't going to be bothered about overage. But, they both might be seen as concerns, but it's all about context. It's all about us knowing our clients. And I just, it just concerns me how this is actually, how conveyancers are expected to kind of absorb this and advise their clients appropriately.
I think the other thing that conveyancers also need to consider or think about is that there will be third-party businesses who offer their assistance to estate agents.
Yeah.
They're already out there.
Yeah.
Some of them are conveyancer friendly, a lot of them aren't conveyancer friendly. And if the conveyancer doesn't get involved now in some way, they're going to be sidelined, I believe, even more than they are at the moment.
Yeah, I think that. So how, you know, what are you recommending to your bold legal clients, Rob, in this regard then? I mean, talking to the agents is one thing, but
well, I've been shown a couple of demos from various systems in the last week or two, and I hope in the new year I'll be able to give a list of potential businesses that conveyancers can work with if they want to. There's one created by Sally Holway. She's an ex-conveyancer that looks quite conveyancer friendly, and there's a couple of others. So I'm looking into those. So look at all the options. I think you've got three choices. You ignore it, which is ridiculous. You fight it, which one group is apparently still trying to do, but it's not going anywhere, or you embrace it. And I think somehow you've got to sit down and try and embrace it, because I think it's here to stay.
So what's the so it's mandatory on estate agents. Let's just remind ourselves, the unregulated, largely in many cases untrained estate agents, but that's a different story. So who enforces it? What are the sanctions then, Rob, if the estate agent gets this wrong? Just briefly.
Well, trading standards will enforce it, probably local trading standards to start with. And again, just looking at my notes, they can actually fine estate agents. They can imprison estate agents. I don't know what they've got to do to get to that level. As I say, it would be enforced by local trading standards. It will also be enforced, and if there's a breach, the two estate agency redress schemes will mention the breaches to trading standards, so they'll sort of police it for them a little bit. But I think ultimately the idea is that it will be not actually policed by the portals, but the big 3 or 4 portals will say, we cannot take your property, your listing, until you comply with this properly. Now, that's not going to happen overnight. Trading standards realise that the portals have got case management systems as well, and lots of things to change. But I think within the next 12 to 18 months, that will happen, and you won't see a listing without most, if not all, of this information.
That's interesting, Stu. What's your view?
I'm just not so sure whether, you know, the industry as a general has got the resource to take that on, and it'd be interesting to see how much that's enforced.
I think that's a really interesting point. It's exactly what I just wrote down. Trading standards, resources, ?
Yeah, I'm just not so sure whether the appetite and the resource will be there, because clearly I cannot see. I mean, are we really expecting, you know, like you said, Rob, all those selling portals to contain all that information? And also, where do you limit this? What happens if it's a really, really, really complicated property that's you know, full of XYZ? You really could be putting off a buyer completely, couldn't you? I mean, I can understand why a lot of estate agents are concerned. I think it is a complete difference, isn't there? That the theory, absolutely not got any problem with the theory. It's the way it's been defined and where you draw that line between, you know, what ventures into the conveyancers sort of territory as opposed to the estate agents. But you are going to be potentially making a lot of properties unattractive.
You could blight some, yeah. You could absolutely blight some near the coast, etc. Flood there. But
and also, Rob, it's interesting. Sorry, just to cut across you there, but I mean, I also think if you think about, you know, part A was, you know, this is material information that estate agents were, you know, are now mandated to produce, you know, tenure, freehold, leasehold, council tax, and price. Well, for goodness sake, that's an incredibly low base from which to then catapult them to part C. I mean, frankly, we might all, it's shocking that trading standards have got to produce a mandatory requirement that an estate agent tells us whether it's freehold or leasehold and tells us the price. I mean, that in itself is utterly extraordinary if you think about it as a starting point. So to take us from that to, oh, now please tell us all about all of the restrictions, the this, the that, the flooding, the listing, the rest of it. I just really struggle. I just don't think that part C has been properly thought through, to be quite honest.
Well, they did have a steering committee. Obviously, I wasn't on that steering committee.
Weren't many conveyancers on it, Rob, I don't think, lovely, to be quite frank.
Well, there were a few who used to be conveyancers, maybe people like me, I'm not going to name names, but some who who know their way around a conveyance. There weren't many surveyors apparently, and they're complaining about that, the surveying
Well,
industry.
their steering group, Department for Levelling Up, Nationwide, On the Market, Property Mark, Property Pal, Rightmove, Coal Authority, Conveyancing Association, Land Reg Lawsock, Property Institute, Property Ombudsman, Property Redress, UK Associating of Letting Agents, and Zoopla. There you go. That was who was on there. So we've got the Conveyancing Association, who, you know, got a lot of time for them. Don't get me wrong, but that's an incredibly skewed list, isn't it? Really.
Yeah, and the CA don't cover every type of conveyancing firm either,
No.
do they? They're usually the bigger firms.
Yeah.
I would have liked to have seen the Bold Legal Group on there, to be honest. Whether I want to spend the time doing it, I'm not sure, but I wasn't invited along, so there we are. The other thing that James has mentioned, which is possibly a way of enforcing it by the back door, I suppose, is they say they're going to have a campaign of education for the buying public.
Mm.
So they're going to say to the public, I guess, you know, this information should be on the listing. If it's not there, come and complain to us. So how big that education campaign will be, I've got no idea.
It all strikes me, Rob, as slightly sort of looking at it from their perspective. That strikes me as turkeys voting for Christmas, because they're just going to be inundated. And if you think about it, you know, On the Market, you know, Property Institute, Property Ombudsman, you know, they all sound sort of taking on this additional obligation, material information obligation in Part C. Why would they want to be taking on more information? I can, you know, I totally get Parts A and B, and I get a bit of Part C, but all of the stuff around essentially what is the intrinsic part of the conveyancing transaction, which is all about context, it's all about risk, it's all about advice. And at the end of the day, Stu and I say this every time we talk, Rob, at the end of the day, the conveyancer is properly insured, which is, you know, where the buck stops. And it's a bugbear that Stu and I have all the time, but it's actually to protect the public. And this does concern me, this potential lack of protection and all this information swirling around, but no context.
Yeah, and let's not forget they are bringing this in, hopefully to reduce, you know, fall throughs, etc., and stop people wasting time and money. But I think you're right. The conveyancer has to get their business plan right on this as to what service they're going to offer, who they're going to offer it to, and what they're going to charge. I would still see it as an opportunity myself. As Stu said, he's pushing against closed doors at the moment, but I think they may start opening next year.
Well, I think that's really, really interesting, Rob. And I think, well, we'll definitely get you back maybe in the first quarter of next year to see how this is going. But we can't really talk to you, Rob, without now talking about two very significant things that you're doing now annually on behalf of the profession, maybe to conclude our chat. But you seem to have single-handedly, Rob, got a fantastic conference and National Conveyancing Week happening regularly in March now. So what have we got coming up? I mean, they're extraordinary things for one person to set up. So good for you. So tell us, let's looking ahead now to 2024. Tell us a little bit about National Conveyancing Week and your fantastic conference.
Okay, well, let's go to the conference first, because that's the easier thing to explain, I think. We set up our own conference, the first one 2 years ago. So that was... well, I say 2 years ago, we've had two now. So that was 2022. So I had one in the summer of 2022, one in the summer of this year. They both went extremely well. We've got a fantastic venue in Regent's Park up in London with a lovely marquee. So it's a day of panel sessions and debate and barbecues at lunchtime. Bearing in mind, it's nearly the longest day and hopefully the hottest day of the year. Then we have the evening soiree. The feedback from both so far has been fantastic. We've actually just taken on our son full time to organise and run the conference for next year.
And what's the date for next year?
It's the 19th of June, as I say, in London in Regent's Park. So we're really looking forward to that. I don't like planning the agenda too far ahead because obviously things can change. I'm sure some of the things we've been discussing today will be on the agenda, but there may well be new things as well. We've got an early bird ticket offer at the moment, which I've put out to our membership. So it's cheaper to buy it now, but it is a blank agenda. So you've got to trust me to put something on the agenda that you wouldn't want to see in here in June next year. And I think most of my members do trust me to do that. So I'm really looking forward to that.
Excellent. And National Conveyancing Week, Rob, because this is very much a sort of, you know, a you impetus as well, to be fair. You've not got a Lifetime Achievement Award, lovely, for nothing.
Well, National Conveyancing Week came about, it came to mind, I suppose, about a year or so ago. I realised I couldn't do it on my own. It was too complicated, too technical for me. So I enlisted the help of David Opie of Today's Conveyancer. And we get on extremely well. We are chalk and cheese. He's very calm, very, sensible sort of guy. I'm the opposite. So we bounce off each other well. We've got both our teams working on National Conveyancing Week for 2024. So some of my staff are working on it. Some of his staff are working on it. Again, we haven't completely fleshed out the agenda yet, but we are working on that. We had about 250 firms involved this year, and they got the free packs from us. So they put some bunting up, they had some cakes, they had some balloons, they had a tea towel with the sponsors' names on, all sorts of things. And some of them really celebrated National Conveyancing Week, which is what we wanted them to do. And we got fantastic pictures that come in from some of them. They even opened up their offices on the Wednesday morning to local estate agents, surveyors and brokers and said, come in, we'll talk to you about conveyancing. And the feedback is some got new work, new contacts from that. So we want to build on that for NCW in 2024, which is in March. I think it's March the 14th it starts, I'm not sure, but it's a week in March, yeah. And it's all free for law firms. They don't even have to leave their offices. They don't have to go anywhere. They just log into the bits they want on the days they want to. It couldn't be better. It couldn't be easier.
Oh, fantastic. Well, as I say, good for you, Rob, and good for David and the team at Today's Conveyancer. Because I think Stu and I say constantly, don't we, Stu, anything that sort of, promotes the conveyancer and the fact that what we do is so hard is a good thing.
Well, I often say, sorry, Stu, I often say I've got survivor's guilt. So I gave up conveyancing, as I say, about 15 odd years ago. And pretty much up to that point, I enjoyed my job. I think if I was doing it now, I wouldn't be enjoying it as much. And I feel sorry for the guys and girls who are doing that at the moment. So I do have an element of survivor's guilt. And if I can help improve the process or improve the way people look at conveyancing and understand conveyancing, then I would like to do that before I hang up my spurs.
Yeah, well, I think there's a really important bit of context to this. And I very, very rarely hear it spoken about. And that is that the industry and people with outside our industry also are always punting change so much. There's a better way we can do this. We should be changing this, blah, 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 blah. But I think it's absolutely essential that we get over the point, and you could call it education, but we get over the point just what an important job a conveyancer does. And I sometimes think that is completely lost because we talk so often about changing everything, that we should be also talking to people and making it clear what we do, because the layman doesn't understand it. They go to buy a house, their initial contact with the mortgage broker and the estate agent. We're obviously, a lot further down the line, but it's essential that we communicate how important our job role is and what we do and the consequences of us not being due diligent and what that would mean.
Or maybe material information will help with that, because if the public see easements, covenants and restrictions, they're going to think, oh my goodness, this is quite a complicated job. I need a conveyancer. And aren't they great? Who knows?
Let's hope so.
Well, here's hoping. Well, on that positive note, Rob, just like to thank you so much for joining us in your frankly spectacular Christmas jumper. And and from Stu and I, we'd like to send you and your family all the best Christmas love, particularly with the new arrival on his way. I just think that's really exciting, and I do hope we see some photos of
you probably will. I won't put it in the bulletin, but it might be on LinkedIn and Facebook. I'd just like to say happy Christmas to both of you and all of your listeners and all of the Bold Group members who are out there.
Oh, thanks, Rob. Will you take care? Bye.
Okay. Thanks very much.
Bye.
Bye.